Hey, all right, let me do before the hour of justice appeals court. Now sitting in Boston, Paul, I think the fellow was right here, executive session. That's it, Massachusetts, school forward.
Good morning, and thank you for glad that we could reschedule this for today. I'm going to start by introducing the panel. To my right is Justice Gregory Massing. To my left is Justice Robert Toone. My name is Ariane Vuono, and I actually don't have the number of the case in front of me right now. I wonder if one of my colleagues does. Oh, here we go. Thank you. It's Commonwealth versus Tyler JACQUARD, 23-0541. Thank you. I don't suppose I have to tell you have 15 minutes, right?
Thank you. May it please the court. Christopher DeMeo for Mr. JACQUARD. I thank the panel for rescheduling. I apologize for the inconvenience.
Did you miss the flight after all or not?
No, I got in early. There was no
There was no snow. Right.
All right. So this is a appeal limited to the motion to suppress. I'm going to take it pretty much in the order it's in the brief, with the out-of-court ID and in-court ID, and then harm. On the out-of-court ID that occurred at the Linfield Mall, there's several factors that the court looks at. I would suggest that they don't weigh in favor of the Commonwealth here. One of them is public danger. I don't want to make light of this crime. It's not anything anyone wants to see when they're pulling into a public parking lot, but the other cases, the Boston case is about armed robbery. The Bohelto case is about armed robbery. They're about murder. The Botev case, which both parties cite, was an indecent exposure, but the man was outside in a park so it's a bit more brazen. Another factor is efficiency. I don't see the efficiency here because the car had been identified, so it seems to me that the owner of the car was going to be part of this investigation no matter what. It took 5 days to arrest Mr. JACQUARD, so it's kind of have to suspend belief that the hour or two that it would have taken, or 3 hours to put together an array, would have affected this timetable.
So the only evidence that I recall in the motion in limine is the officer or some officers drive by the house right away.
Correct.
But the defendant's car isn't there, and that's
Right.
That's the only evidence of any type of
Follow-up. Yeah. Well, I guess to be fair, the officer walked around the mall and looked for video cameras. But as far as tracking down the owner of the car, yeah, that was the only evidence.
And how many days later was he arrested?
It was 5 days later. Some other factors: there was no Silva Santiago warning. So the Commonwealth cites a couple of unpublished cases. They both had some kind of, I don't know if they got the full Silva Santiago German language in both of them. I think they did in the more recent one. So that's another factor. It seems to me there's a special suggestiveness here because you know that the witness has identified the license plate, and then the officer says, "Oh, okay," and then he goes back to the cruiser, and then comes back and says, "Is this him?" The photo is in the record.
Isn't that different? Like, it's not a case where the police think it's somebody and show the witness, "Is this who it was?" The witness says, "I've got a video. I took his video, and I'm giving you the license plate. Here's the license plate." Doesn't it kind of make sense to just quickly confirm that's the right?
I mean, it doesn't, because it's suggestive, and as I was saying, the photo that's in the and also she didn't describe the video. What happened is she gave him the license plate, but he didn't learn about the video until the next day when she posted it on Facebook, and somehow it got back to him, and there was follow-up. So he didn't know that at that point. He knew there was a license plate. He went to the cruiser. He comes back with what seems to me to obviously be an RMV photo. It's a face in front of a blue background.
That's Exhibit 2 that we have.
So I think that's in the record. So it seems to me that's a sort of an extra point of suggestibility that you kind of know that it's the guy who owns the car that it's registered to. So it seems there's a lot of problems here, I would suggest, and every one of these cases turns on the facts, so maybe it'd be a different fact if he wasn't in his car and it was more brazen, or they'd gotten a...
We learned from McManus's testimony that later she posts something on Facebook because she figures out that he's a registered sex offender. Can we, and there's some, and there's some inkling that the police, after she says, yes, the police nod knowingly.
Right.
Is there, in terms of the need for a quick investigation, can we consider that?
Well, I mean, they didn't know he was, well, I don't know if the officer said he'd heard him in roll calls in Melrose. I don't know that he knew, that he was a registered sex offender. The nodding, I haven't made a big deal of in this case because it happened after the identification, she said, but it does kind of show you why it's important to have a good protocol, preferably double-blind, because, I mean, if they're giving these kind of smirking and, nonverbal cues to each other after, then, who knows how he presented it. It was like, could it be this guy? There's a lot that depends on how it's done. So I realized that happened after the identification, so I didn't really press that here.
Isn't really one of the questions we have to answer is what was the extent of the effect that this ID had in the case?
That is, yeah. I mean, and that's, and that kind of segues into the in-court identification. So if, my argument is Creighton, if the out-of-court is bad, then the in-court, it's like dominoes knocking over. The in-court falls too. The Commonwealth's arguing, well, there was an...
That doesn't always happen in our cases, right? The in-court does not always fall afterwards, even if we were to say, and it's hard to say that there wasn't some problems with the ID identification procedure here, right? Without tipping any hands or anything like that, but there's some, and the Commonwealth acknowledges that as well, that there's some issues.
I mean, there could be an independent. I mean, the independent basis doctrine, as I understand it, is you don't want to spoil what is a good identification or would have been a good identification anyway, just because. Someone makes a mistake with the photo array or with the show up. The Commonwealth says in its brief that the Judge Barrett found an independent basis. I'm not sure. It's hard for me to tell what he's saying because he doesn't use the word independent. He talks about reliability, which is something else. But regardless, I would submit here that this is not a case where you could find by a clear and convincing evidence that there was an independent source for her identification such that you can be confident that if this hadn't happened, she would have identified him. She didn't know the guy, so that counts against it, although Judge Barrett.
Well, she did have the opportunity to observe him. According to the video that we watched,
Right. She didn't know him, so it wasn't like she saw him there at lunch every day. She said she didn't see him until she got out of her car. She did take a 23-second video, which we've all seen.
And which
it's not very good.
Well, you can see his face.
You can see his face at the beginning, and then it's like most of it's pointing
zeroes into the
I know
license
she's trying
plate.
to get his license plate, which makes sense. So it's kind of pointing down, and we don't. Maybe she was looking at him while she did that, but we just don't know. It's not very good. So the question is, can you say to a clear and convincing level that if she had gone instead and had a fair photo array with 8 guys with a scruffy hair and scruffy beard, that she would have picked him out? I'm not sure that she would have. I mean, it's not good enough just to say she probably would have, because it's not preponderance, it's clear and convincing evidence. Right. And I would submit that's...
What about the point that the parties stipulated at trial that the defendant was the person in the sedan who...
Right, so that gets into the harm. And as far as I put a bunch of cases in the reply brief, but it seems to me there's nothing to prevent defense counsel from doing what she did, and she was clear. I have a cite here. It's at volume 2 of the trial. It's the wrong site. I think it's pages 83 and 84. So the same time that she stipulates, she says, I'm renewing my objection, which she's done several times previously. And the judge says, okay. And then she says, but I'm just going to stipulate to this. And I cite cases where that's done. I don't see why that shouldn't be allowed to preserve it as an appellate issue and just to simplify things for the purposes of trial. So it is true, identity was not an issue at trial. But my point is that if
Point
this
is,
had
it
been
would have been, is that
suppressed,
your point? Your point is that it would have been.
It would have been if it had been suppressed, right? And I think that was trial counsel's point, too. This was preserved. It's the highest standard. It's harmless beyond a reasonable doubt.
Right. So can we address that? So without McManus, you'd still have her video, right?
We have her video. We have the license plate number. So, I mean, I'm not saying there's not enough to convict him.
You could, if you could frame by frame go through the video and see. I mean, there's the Commonwealth mentions something about a tattoo. You can see a tattoo on his arm.
I don't know. I'll let the court defer to that. It's not very good. I've been through the video several times, but yeah, I mean, there would be enough to convict him. We're definitely not arguing Lattimore here, but that's not the standard. The standard is the court has to be sure beyond a reasonable doubt that these identifications would have had no effect on the jury, and I just don't see how you can. There's 3 identifications. There's McManus talking about what she said to the cop at Linfield Mall. There's Officer De Palma himself saying what she said, which comes in for the substance, and then there's her saying, he's that man over there in the striped tie. So it comes in 3 times, and I don't know how you could say that there's no way that could have had an effect on the jury. They certainly could have convicted him without that, but
So wait, this is kind of an interesting point you're bringing up. I hadn't really focused on it, but do we look at it as with that, knowing that they saw that they did have the ID, and then trying to figure out if that was harmful, or do we pretend that they didn't have the ID and think of what the case would have looked like without her ID?
Well, I don't think you do it the second way, because again, even without, I'm not arguing that without the ID they couldn't have convicted him. It certainly would meet Lattimore if they look at the video, and
right.
I don't think it's a very good video, and the prosecutor herself said, when she was trying to get everything in, she said the video is no slam dunk, you only see him in profile for an instant. I concur with her, so I don't think it's that great, but certainly it was enough to convict. What I think the analysis for harmless is, it's the standard I just said, which is the court sure beyond a reasonable doubt that the erroneous information had no effect on the jury. And it's a hard.
Then that plays right back into the stipulation piece, because we can't subtract the stipulation at that point, because if the ID hadn't come in the beginning, then the Commonwealth would have put on other evidence.
Well, I don't. The fact that she stipulated. I mean, the fact that she stipulated to it.
It prevents the Commonwealth from putting on further ID evidence.
I mean, if the court wants to if the court wants to make it completely a kind of counterfactual of what would have happened in this other world where this happened, and they want to look at the tattoo, I guess they can do that. But you certainly can't consider the fact that she stipulated to it, because when she stipulated, she said in the same breath, I'm continuing to object, this should have never come in. The case that the Commonwealth cites where there was harmless beyond a reasonable doubt, just to give the court some idea, is the Howard case from 2006. That's a case where, it's just a good example because it was a case where a 13-year-old got pregnant. She blamed her uncle. She had a child. They tested the child and uncle's DNA. It was his DNA. He was unquestionably the father. And then somehow he said something slightly inculpatory to someone at some point when his lawyer wasn't there. And the SJC said, well, I mean, it doesn't matter because she said it was him, and she had his child, and there's DNA. So that's the kind of very strong evidence where you can say that the erroneously admitted inculpatory evidence is just very minor in comparison. And I don't think you can say that here. I think the 3 identifications I just talked about, they're pretty important, even with the video and even with the license plate number. So those are the main points I wanted to make.
Just the 3 IDs are?
Well, it's 2 IDs really, but the jury heard it 3 times. They heard McManus talk about, I identified him to the officer at the mall. They heard the officer say, She told me that's him, and then the third one in court when she said he's sitting right over there, so. All right. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Kayla Burns for the Commonwealth. The Commonwealth asks that this Court affirm the denial of the defendant's motion to suppress and affirm his conviction of open and gross lewdness. And I'll start with I'll go in the same order as we did with defense counsel to the out-of-court identification first. And here, there was good reason to conduct this single photograph identification procedure. I think first and foremost, the serious nature of this crime really highlights the importance of conducting this ID procedure. This was a sex offense that was committed in a public area, and what Ms. McManus explained was in front of teenage girls. Certainly, this defendant was in his vehicle at the time, but it's clear that this was observable. Ms. McManus did observe it herself, being right next to this defendant. And I think the serious nature of the crime also plays into the public safety concerns here. Again, this was a sex offense that was occurring in front of teenage girls, and these officers also had prior knowledge of this defendant and that he had engaged in sexual offenses prior to this day. And I think that knowledge also plays into the public safety concerns that the officers had at the time and the importance of conducting this ID procedure at that time.
Why couldn't the officer give the instructions, the Silva Santiago instructions? I mean, I understand showing just one photo, maybe that's appropriate, but why can't you give the instructions?
Truthfully, Your Honor, I'm not sure. I don't think there's anything in the record that indicates why the instructions were not given in this case. Certainly, that is best practice. The courts have encouraged that this is done in these type of ID procedures. I don't have an explanation as to why they were not done in this case. But I think the court, the motion judge who reviewed all of the evidence and heard the testimony, he did take that factor into account. And I think he's very clear that in assessing all of this evidence, even taking into consideration the fact that these instructions were not given, nonetheless, all of the facts presented support the finding that there was good reason to conduct this ID procedure.
So how do you respond to Mr. DeMayo's argument that it wasn't really that serious emergency when they do a simple drive-by of his house and then they let it go for 5 days?
Well, respectfully, Your Honor, I'm not sure they let it go. I know that there is limited evidence as to what exactly was done in those days after the day of the incident, but I think presumably there was an issue finding him perhaps at that point. I know on that day the evidence as to the investigation that the officers undertook was limited to the fact that they had Melrose officers drive by his house and that the officer at Market Street kind of went around the area, looked for security footage, was not able to find any. And I understand that's the extent of what was done that day, but I'm not sure it's fair to assume that nothing was done until the defendant was arrested. And I think that also doesn't negate the importance of identifying him at the scene at that time. And I think the cases make very clear that having this ID procedure as quickly as it was done in this case, and I think arguably it's within a half an hour of when Ms. McManus observes the defendant, and the cases make very clear that having an ID done that quickly kind of helps preserve the witness's memory at that point so that no other information can come in between and essentially taint her memory of what happened at that point.
That's kind of true of every criminal offense, right? I mean, the trial judge says, well, this was reasonable in view of the usefulness of prompt confirmation of the accuracy of the investigation's information. I assume that's true of every criminal investigation that's conducted. It's helpful to have prompt confirmation of information. Can you give me an example of maybe a case where it wouldn't be acceptable to sort of disregard the protocol here?
I think it's in a case where there's less of a public safety concern. I think perhaps, I can't think of a particular crime off the top of my head, but I think in a case where there are not public safety concerns, and I think those were particularly salient here. Again, we had a sex offense that was in front of in a public area with teenage girls, and the officers did have concern that this defendant was still in the area, or if it wasn't this defendant, that the person who did do this was still in the area. So again, I apologize, I can't think of a particular instance off the top of my head, but I think it's where there's a crime, where there's less of a public safety concern, that perhaps there's less of an importance of IDing someone immediately after a crime.
Yeah. I mean, the defense sort of says, well, this is a non-contact sexual offense. Does that difference? Does that make a difference in your view?
Respectfully, I don't think so, Your Honor. I think this still is an instance, and again, I understand this defendant was in his vehicle at the time, but he was still observed by someone, and I don't think just the fact that he was in his vehicle precludes it from being a public safety issue where he was clearly observable by someone who was right next to him, and even though he was in his vehicle. So I suppose I'll move on next to the independent source, the in-court identification procedure. And certainly, I think in the motion judge's findings and rulings, he certainly does not mention the words independent source. But I think the specific findings that the court makes indicates that that is what was being contemplated. And I think when you look back at both of the parties' arguments at the motion to suppress hearing, they both separately argue the independent source issue. So I think the issue was readily presented to the court, and I think that the specific findings made by the judge indicate that that's what was being contemplated at that point. And I think some of the factors that are really important on this issue is the fact that the video indicates it was a sunny, bright, clear day. Ms. McManus was merely feet away from the defendant, and it's clear that she had no obstruction and was able to see exactly what the defendant was doing in his vehicle, was able to see his outfit, could see his profile, could see that he had a scruffy beard, medium build, brown hair, all of those things.
I assume at trial he didn't have a scruffy beard anymore. Do we know?
I can't remember off the top of my head if that's in the record at trial. I'm not sure.
I mean, right, because that would make it less reliable. When did the judge at the motion in Lemonade decided the independent source?
Yes, that was my impression from the judge's findings and rulings. Like I said, both parties argued independent source at the motion to suppress hearing, and I think the findings of the judge indicate that that's the issue that was being contemplated as well.
So she had what, like, I mean, the video's 22 seconds. How long did she have to look at him?
I believe it's probably about 30 minutes, 30 seconds. I believe it's about 30 seconds because I believe she says she observed him and then took out her phone and began recording. So I don't think her observation was much longer than what was recorded on the video. But I would say it's probably about roughly 30 seconds that she was able to observe him. But I think, and I recognize that there are cases that highlight a longer time period, but I think here, the closeness of Ms. McManus to the defendant and her view, especially that she had of him, I think that is important for the court to take into consideration, even considering where the time frame may be shorter than is described in some other cases. Because I think the quality of the ability of her to observe the defendant is important.
Can we take into the account that she then went online and found him? Does that support the idea? Or?
Certainly, it doesn't impact the out-of-court identification, and I also don't think it impacts the in-court identification as well, because that analysis is based on her opportunity to observe the defendant at the time of the crime. So, and I think all of those factors do support the fact that there was an independent source for her in-court identification. I think, truthfully, the fact that she did this separate research subsequently, I don't think it has an impact on either of the identifications in this case, because I think both of those look to what happened at the time of her observations of the defendant and then what happened at the ID procedure.
Although it's certainly in her head, right? When she gets to, when she gets to court, suppose they don't introduce the ID procedure. It's in her head, right? Like that has cemented her impression.
I think that's fair, Your Honor, but I think when we look at her observation to observe the defendant, and the Commonwealth's position is that her ability to observe him in that moment, particularly in the moment where she's observing someone behaving the way the defendant was, that opportunity was enough to create this independent source of her identification, regardless of I think what happened.
Do you think it would have made
afterwards.
a difference if her investigation, so-called investigation, was done on her own, or if it had been done on the prompting of somebody else? For example, let's say she had called the police officer and said, I think X, Y, and Z, and then there was a conversation about, well, go ahead and check it out, or did you do a search, or something like that? Would that have made a difference?
I think perhaps if she had said something or an officer had said something to that effect at the time that they were talking to her about her observations, I think perhaps that would make a difference.
No, I mean, even in between that and the time of trial. In other words, it seems to me that a good part of your analysis is that that investigation was done without any law enforcement control or prompting or anything like that.
Right, and I think if her investigation was done at the prompting of an officer, I think it perhaps would be a different analysis or a different way to think about it. But I think here, where she did do it on her own, and like I said, I think especially if the officers had said something to her at the time that she was describing her observations, I think that certainly would have made a difference. But I think even if it happened afterwards, I suppose it would make a difference. But here, where there was no sort of prompting or anything, I don't think it makes a difference in this analysis, again, because I think it goes back to the factors that the judge found for the independent basis, right? And I think the fact and the opportunity and the quality of the observations that Ms. McManus was able to make at the time, I think that is critical in this case, and shows that she had an independent basis to make this identification of the defendant in the court. And then, even if this court were to find that the admission of this ID testimony was an error, that the motion should have been denied, the Commonwealth's position is that this error would have been harmless beyond a reasonable doubt. And certainly, as Your Honor pointed out, this is a bit of a tricky issue for the Commonwealth because there was the stipulation in place.
Yeah, what's your view on that? I mean, I know, I expect, like, if there's a Fourth Amendment suppression issue and that's denied, the motion's denied, and then someone stipulates to the admissibility of the drugs or whatever, that's one issue. But it does seem different if you're stipulating to an identification, which is sort of really fundamental to the case. So how do you assess that issue?
So the way I think it would need to be looked at here by the court is in the context of the factors that the court needs to look to whether this issue, whether the admission was harmless beyond a reasonable doubt. And I think, and I just outlined some of the factors here, and it's the importance of the evidence in the Commonwealth's case, the relationship between the evidence and the premise of the defense, who introduced the issue, the frequency of the reference, whether the admitted evidence was cumulative. And I think certainly it does pose an issue for the Commonwealth to argue now that this error was harmless beyond a reasonable doubt because we had the stipulation in the Commonwealth, and I think the record makes clear that the Commonwealth did have more evidence as to identification that the Commonwealth chose not to introduce in light of the stipulation. So it does put the Commonwealth in a bit of a tricky position on this issue.
So do you think we should look at it, just like subtract the identification and see what's left, or but then we have the stipulation? I mean, on the one hand, you can't really hold that against the defendant because, but on the other hand, you can't hold against the Commonwealth either.
Right, and I think that's why it does present a tricky issue. But my reading of the case law and my understanding of the issue was I believe the court needs to look at everything in the context of what came in at trial, the fact that ID was not an issue, with the caveat that ID was not the issue because the defendant stipulated because his motion to suppress was denied.
What's the thing about the tattoo? And it was in a motion hearing and.
Yeah, so I can't remember if it was the motion to suppress hearing or if it was just pre-trial, but the Commonwealth indicated and sought to admit pictures of the defendant's admission at the Essex House of Correction that show that he has a tattoo on his left forearm. So the Commonwealth sought to introduce those photographs because in the video that Ms. McManus took, you can briefly see that tattoo on the defendant's forearm. So the Commonwealth sought to introduce those photographs to show the tattoo on the defendant's arm and then show that that tattoo was also in the video. And the court didn't make a definitive ruling on that issue, but did indicate that the court would be inclined to allow those pictures in because the court believed that it was very important to the identification issue.
And somehow sanitized to leave out the fact that it's at a jail or
Correct, exactly, correct. So, and I included that simply because I acknowledge that this issue is quite tricky for the Commonwealth, where there was the stipulation in place. And I understand it is also complicated for the defendant as well, because both parties kind of went through this trial with the understanding that this issue was going to be stipulated to and made certain choices based on that stipulation. But I think the court does need to not take that fact out of consideration, but consider everything as a whole. The evidence that came in, what other evidence came in, and I think the record makes clear that there was also additional evidence of identification that the Commonwealth would have sought to admit as well, and it did seem that the court was inclined to do so. If there are no further questions, the Commonwealth will rest on its brief.
I see no questions. Thank you both very much.
Thank you, Your
We'll
Honors.
take the case under advisement and get an answer to you as soon as we can. Thank you. Court will stand in recess.
All rise.
Signs backwards.
Just call a stand and a recess.